All right, good morning, everybody. Let's see here. County Court Law number 4 is now in session uh, for the July 15, 2020 docket. And let me see here. I have CL 19-16-16D, Berto Moreno versus Brisaida Gonzalez, Tony Randall Harris, Triple H Trucking LLC.
Good morning, Your Honor. Mario Garcia and Keith Livesey on behalf of defendant and counter plaintiff Briseida Gonzalez.
Morning.
Dale Kosofsky here for the plaintiff, Berta Moreno. I don't really have a dog in this particular fight.
All right, good morning.
Good morning, Your Honor. Michael Guerra here, also on behalf of Briseida Gonzalez in her capacity as a defendant.
Morning. You need to unmute Mr. Garcia.
Hello?
Can you hear me now?
I can hear you, Judge.
Okay, there we go. Good morning.
Morning, Judge.
All right, good morning.
I'm present on behalf of defendant Tony Riddell, Harris, and Triple H.
And Triple H. All right, good morning.
Good morning.
Yes, and this is a rehearing, right? Motion for rehearing?
That's correct, Your Honor. It's defendant and counter plaintiff Briseida Gonzalez motion for reconsideration of a prior motion of summary judgment that the judge ruled in favor of defendants Tony Riddell Harris and Triple H Trucking LLC.
Okay. All right. And so I remember that hearing right before the pandemic hit us. It was on counterclaim allegations, right? That
Yes.
allegedly were not timely responded to. Is that what it is?
That's correct, Your Honor. The defendants filed an MSJ based on statute of limitations defense. The court granted that right about the time of the pandemic. I was not involved in the case at that time.
Right.
That's correct,
Okay.
Your Honor. And
Okay, so now you want
Go
you want a motion for rehearing because go ahead, Mr. Garcia.
Yes, Your Honor. The court had previously set this hearing for May 18, 2020, but the court canceled that hearing, I believe, based on the orders of the Texas Supreme Court because of the COVID emergency. So the court set that case, reset it to today's date, Your Honor.
Okay, which is July 15, right?
That's correct.
All right. Okay.
And Your Honor, before I begin urging the motion, I'd like to point out that although the judge granted the summary judgment for the motion for the defendants, it is an interlocutory judgment. It's not a final judgment because there's other parties still involved. That particular ruling does not resolve all of the pending claims and against each party in this case. So it's not a final appealable order,
Okay.
a final order or final judgment. It's an interlocutory order. So that with that, Your Honor, if I proceed, unless other counsel wish to chime in.
All right. Mr. Joe Garcia.
Yes, sir, Your Honor. In spite of their arguments, Your Honor, they had an opportunity when we had this hearing before, and they had an opportunity to present all of their arguments and all of the case law. Judge, regardless of what they present to you, I sent a letter yesterday, and I apologize.
Mr. Garcia, I can barely hear you. You're kind of low in your.
How about now?
Now, got it.
All right, Judge, I was not aware of Mario Garcia's involvement, so I filed a letter with the court yesterday. Obviously, everybody that was in the case has been copied, but he was not copied with it, I don't believe. But nonetheless, Your Honor, all of the arguments were already presented to you. There is really absolutely nothing new that they are trying to argue before you. In the letter that I submitted to the court, I've indicated that the court has lost plenary power. With regard to their efforts to try and ask for a reconsideration, Judge, the timeline that that the court considered, and there's just absolutely no way around it, Your Honor. This case, the statute of limitations expired Your Honor, and several months later, on August the 12th, well after the expiration of the statute of limitations, is when they filed their lawsuit, and it expired in April, Judge. So it's not even a close call. On April of 2019, the 2-year statute of limitation expired, Your Honor. I mean, that's just black and white. And on August 12th is when they filed their claims. So I don't believe that there's an extension of the appellate rules. And they're very specific in terms of what they're supposed to do. And the reason why Mr. Mario Garcia makes that argument to you that it was previously set on May 18th, it's because this court, with regard to this motion and with regard to the court's order, uh, uh, the appellate rules 329B tell us that it's overruled by operation of law if it's not ruled on within 75 days from the time that the court granted the actual motion. And the court, of course, granted that motion on March 2nd. So we're way beyond 75 days. There is a clause in there, a little exception that allows you to hold on to plenary power 30 days after the 75 days expires. That would have been in June. So, Judge, we're in July, and if the court feels that those rules don't apply, which in my opinion I believe they do, there is nothing factually that is different. They just missed it, Your Honor, and I apologize. There's just no other way of articulating that to the court and to the parties. And it was the right decision then, and it's the right decision now.
Okay, let me hear Mr. Mario Garcia.
Thank you, Your Honor. Your Honor, this, as I mentioned earlier, this particular ruling by the court it's in the form of an interlocutory order. It's not a final order with regard to disposing out of the parties. So I think Mr. Garcia is jumping over that particular hoop. That is a barrier that he has not overcome. And again, we also reiterate the argument that the court had set this case for an earlier time. However, unbeknownst to us, this pandemic hit, and I believe that although we don't know the real reason behind it, I believe the court did reset the cases, has been in other courts throughout the state because of the pandemic, and there is a Supreme Court order in effect that extends the deadlines to September 30th of 2020. But that being the case, Your Honor, as involved the argument on the motion reconsideration, that our particular motion centers around three particular sections of the Texas Rules of Procedure. And one of them, Your Honor, I'm sorry, Texas Civil Practice Remedies Code, they're basing their particular argument on section 16.063. We've alleged that section 16.069 is an exception to this, even though Joe Garcia would like to argue that it's an absolute bar. This particular section of the Civil Practice Remedies Code that he urges, there are at least two exceptions to it, and this is a particular different case. It's not a straight up plaintiff versus defendant case. This involved a plaintiff versus defendant and then a counterclaim against the parties. My client got sued by the plaintiff, got brought into this lawsuit, and then so we followed the rules. We filed an answer, even though we were not required to, Your Honor, because, as Mr. Livesey argued in the first hearing, there was a defect in service upon our client. So our client was not served properly. At the time of the hearing, the citation was not on file with the court for the requisite 10 days. Also, there are defects as to how the particular citation was returned to the court. It wasn't returned properly. It didn't mention the court, the style, the case number. And as the court knows, service is absolute. You have to cross all your T's, dot all your I's to make sure that service is perfected. If not, my client would not have to answer. However, she did answer on August 12th, 2019, and she did provide a counterclaim within the time required by section 16.069 069. And I could quote to the court, this particular section says that if a counterclaim or cross-claim arises out of the same transaction or occurrence that is the basis of an action, a party to the action may file the counterclaim or cross-claim, even though as a separate action, it would be barred by limitation on the date the party's answer is required. And in section B, the counterclaim or cross-claim must be filed not later than the 30th day after the date on which the party's answer is required. So this particular section applies here because all this case, all the parties and the issues arise out of the same transaction, namely a automobile accident. My client was a driver of a vehicle that was rear-ended by Mr. Joe Garcia's clients. So we got sued by the passenger in the vehicle. And so we filed an answer to that lawsuit, and we filed our own cross-claim or counterclaim against the defendant truck driver and company. So the court has that particular section that deal with as far as carving out an exception to the initial statute of limitations rule. I'd also like to point out to the court that there's another section that would apply here because this defendant is a truck driver, Mr. Tony Riddle Harris. So a lot of times he's absent from the state. So one of the things that can happen here is section 16.063 would apply to this particular case. It would toll the statute beyond what occurred because the defendant, being a truck driver, is out of the state. And I believe the companies also would be out of the state. So the truck driver would be acting on behalf in the course of scope of employment of the defendant, Triple H Trucking LLC. So I think the court has several issues here, which raises fact issues as to the initial motion for summary judgment that was urged by the defendants. Also, on a side note, Your Honor, Mr. Livesey did tell me, and I think you put out to the court, that in the initial motion for summary judgment, he was not provided with any type of service of the hearing of that judgment. He only found that out through, I believe, other counsel in this case. So I think that in itself is a violation of the rules and would require this to be reheard. But nonetheless, Your Honor, we stick by our arguments that my client, Peseda Gonzalez, defendant and counter plaintiff or cross plaintiff, can also stay in this lawsuit. She has made several exceptions here to the general rule, and I call it general rule because the legislature would not have passed these particular statutes if this was an absolute rule, where 2 years, and that's it. They have provided these statutes, and there is case law supporting our position. Mr. Livesey has briefed them well and provided them to the court previously, and he's also listed those cases in this particular motion. And if Mr. Livesey wants to add to that, Your Honor, I would cede to him and then pass over back to the defendants.
Anything, Mr. Livesey?
Yes, Judge. If you look at the statute at 16.069, the statute says is required to file an answer. And Mr. Garcia at the last hearing kept on harping and saying that you're required to file an answer whenever you're served. And I kept on saying no, but I lack Mr. Garcia's theatric ability and persuasiveness to get my point across. But in the motion for rehearing, we clearly present additional authority, which specifically says it doesn't matter when you're served to determine whether you're required to answer. You have to be served properly. And that did not occur in this case. We were only, when we filed the answer, we filed the cross-claim immediately. And so, again, the statute didn't say whenever served, it said whenever required to file an answer. And so the case law we presented, I think takes care of Mr. Garcia's, Joe Garcia's argument. I would also point out that This is not a final judgment. It lacks anything concerning, you have to have magic language for finality. It lacks that. It doesn't even, it doesn't assess court costs. There's no severance. And so the plenary power rules under 329B clearly do not apply because we've got other claims that are currently pending, including claims by the plaintiff against Mr. Mario Garcias and my client. And so we're requesting that the court, and we'd like an opportunity to depose the truck driver and specifically find out what are your routes, how many days are you out of the state, and if he's out of the state 3 weeks a month, then we will be very clear that we can come under the other statute about, the tolling when the party is out of state. So we're requesting that the court set aside the motion for summary judgment and let us back into the lawsuit.
All right, thank you, Mr. Lifesay. Mr. Joe Garcia?
Yes, sir, Your Honor. Thank you.
Yes, sir.
Judge, they're really engaging in verbal acrobatics.
I can barely hear you, Mr. Garcia.
They are engaging in verbal acrobatics. Judge, the court's rulings were proper. The argument that they're making is that they're complaining about service from the plaintiff. They're not complaining, and now they're complaining about service from the court, and I guess me and the court coordinator with regard to them not having notice of the hearing on March 2nd when this matter went forward. Interestingly, they were there, and interestingly, they had a response, and interestingly, they made their arguments. So I understand the difficulty of the nature when someone loses a motion for summary judgment, but the courts aren't here to correct and fix all of the mistakes that exist in the file, and the court can't do anything with regard to the dates that are fixed, and they clearly missed the April deadline to assert any kind of claim that they wanted against our defendant. My defendant is a Texas resident. He's not been out of the state. There is nothing in the law that says that a Texas resident and his employees somehow extend the statute of limitation if he drove a truck and crossed the state line. That they're stretching, Judge. My client is a Texas resident. It's clear on the pleadings, and Judge, they also are trying to cite different rules that potentially might apply here so that you could hang your hat on something. With all due respect, none of those apply in this case, Your Honor. I'll give you one example. Rule 107 has to do with default judgments. This isn't a default judgment. They're talking to you about Rule 107 and how that rule permits them to extend based on service because of default judgment. Judge, they entered an appearance, they filed their answers. I'm the defendant. They sued me. They can't be complaining about service with regard to the lawsuit that they filed against my client. If they got beef with the plaintiff, that's for them and the plaintiff. They're related. They're in cahoots with each other. They're coordinating this claim together. And now they want to point back up the line and say that the plaintiff didn't sue them properly. They filed the answer in this court, Your Honor. I asked the court to take judicial notice of all of the pleadings on file. You will see that they filed an answer for all intents and purposes. And once you do that, you can't come in a year later or 8 months later and say, oh, by the way, although I have been engaging in discovery and although I had an answer on file with regard to the plaintiff's claims and although I sued other people, I wasn't sued. I wasn't sued properly, and I'm not properly in the lawsuit. This is where that argument fails miserably. Let's assume they're correct, Your Honor, and that they're not properly in this case. Well, then there's no claim against me. And if they want to try and bring it today, it would even be further removed from the statute of limitations, and they would have missed it now also. If you want to give them an opportunity to have the plaintiff sue them and serve them properly, it's nonsensical, Judge. They're in this lawsuit. They sued us. They made us expend time, and money, and they cite to you Rule 107 that extends it. It does not. That has to do with default judgments, and they didn't do it. They didn't file an answer in this case until an action against me until August the 12th, 2018, many, many, many months beyond the statute of limitation. Again, Judge, Rule 107, Texas Rule of Civil Procedure, has to do with default judgment, and using the two ingredients that we've already hashed all of this out with you, Your Honor, in the previous hearing. Rule 107 does not extend the deadline prescribed by Section 16.069, which is in the Texas Civil Practice and Remedies Code, concerning her cross claim. They're trying to get a default judgment statute having to do with a dispute between the plaintiff and them, and say, oh, because of that unrelated lawsuit in which I was sued, I'm using that to extend my appearance in this case with regard to the lawsuit that I'm bringing against someone else. Judge, the rules don't, I mean, I'm sorry, Your Honor. Forgive me for my frustration. There's just nothing there. They improperly apply the default judgment to the fact pattern in this case in attempt to have you extend the deadline of the prescribed 16.069, which is fixed, dated, and unwaivable. And they're just wrong. And there is no such relief for them in that instance. In addition to that, Your Honor, I understand we all have to be careful with regard to COVID and practice social distancing. But one thing that the Supreme Court mandate and orders did not do is amend the law in the state of Texas. It did not amend and supersede any existing case law. It did not amend the rules of civil procedure. It didn't do any of that, Your Honor. For them to say that it did, and that the Supreme Court has now changed all of the rules of civil procedure and all of the case law that exists in this case, is again another nonsensical argument. All it does, Your Honor, is extend and modify courts' scheduling orders, and that there can be no trials and no in-court juries, and we know that. But that's not the case in this case. So one thing that is not that is missing from their argument, they can't argue now that they weren't served with our summary judgment. He was served via ProDoc, Your Honor, and I showed the court those records when we were in court last time, and they were properly served on January 23rd, 2020 at 3:42 p.m. And so they've been properly served. There isn't any concern that the court should have with regard to this court having given all of the parties proper notice with regard to the hearing. These claims, Judge, are simply barred by limitations, and the court's rulings should stand, Your Honor.
All right, thank you, sir. Mr. Mario Garcia.
Your Honor, there's a couple of misconstructions of the law that Mr. Garcia made there. For example, on the section of the 16.063 of the Texas Civil Practice Remedies Code, it doesn't matter you're a Texas resident. It applies to you whether you are or not. So you could be a Texas resident and go out to Mexico, or like Mr. Livesay suggested, travel your routes, be out of the state. And this case, the defendants are saying that the statute expired in April. The service here, or the Keith, Mr. Livesay filed was in August. So it's not many months. It's 4 months, and it's not impractical for a truck driver to drive routes out of the state, Your Honor, for what that winds up for many months. And then also, Mr. Garcia was incorrect on the Texas Supreme Court orders. They did suspend and told statutes and answer deadlines during this time, as the judge is well aware of this. It's very explicit, specific. They filed several orders, and the latest order extended to September 30th. The Supreme Court of Texas has been setting the deadline and then extending it because of the current COVID pandemic and because certain lawyers' offices, especially in the big cities like Houston, who do not have staff that are working in the office or remote, so they have no one's available to be served, or even the actual defendant on the street, because their businesses are closed, may not be available. So that's incorrect statement made by Mr. Garcia. Your Honor, what we're saying here is that these are two exceptions to the rule that Mr. Garcia is alleging or alleged in his MSJ. And again, like I stated, why would the legislature pass these rules, these laws, if it was an absolute rule? There are exceptions that deal with these situations, such as this one, which we know it's not a default judgment, Your Honor. So that's another red herring in Mr. Garcia's argument. The section 16.069 directly applies to this type of case. I'll end it there, Your Honor, and request that the court reconsider the ruling and reinstate this case, overturn the summary judgment in favor of these defendants. I'll let Mr. Livesey say something. I think he wants to chime in, Your Honor.
No,
Mr.
Judge,
Lysa?
yeah, Judge, I would just add this, that when I studied logic in college, Mr. Garcia is using the logical fallacy of the straw man, and he makes arguments and that we did not make, and then beats them down. And so Mr. Mario Garcia addressed the substance, but I would just remind that he's trying to beat down arguments that we don't make, and so of course he wins doing that, because those aren't the issues. The issues are what Mr. Mario Garcia set forth before this court.
All right, Mr. Joe Garcia?
Thank you, Your Honor. They can argue all they want, but there is no evidence with regard to what they've articulated to you here today.
Okay.
They've not told you at all that my client is not a Texas resident. They've not told you at all that my corporate client is not a Texas resident. They've not told you or submitted any kind of evidence that we were out of the state. We're a Texas company, Your Honor. We reside, live here all the time. It doesn't matter if an employee crosses over, doesn't cross, we're still here. They don't address that for you at all. They don't give you any information about that. And they can say that I'm raising up straw men or whatever. Judge, they're the ones making the arguments. They're the ones saying that that Rule 107 allows them some relief because they were not properly served, and that there can be no default judgment taken against them. This is not a default judgment. Consequently, then it cannot apply to 16.069, because they're the ones that are trying to muddy up the record to try and desperately find something that would give them some relief. No argument that they've made is supported by the facts, supported by the record, and supported by the law. The Supreme Court mandates did not change the rule of law, did not change the prevalent case law that tells us, you know, what these courts are supposed to do with regard to the application of law concerning someone. 4 months, they admit, at least, Judge, that it was 4 months that they missed the limitation and that it wasn't 8. Okay, they missed it by 4 months. Judge, the rulings were correct, they were proper, and there's no basis on this record and no basis in any of their briefing that permits them and or allows them to continue to waste valuable judicial resources under this environment of COVID-19 and inappropriately bring or have claims asserted against two parties that this court has already granted a summary judgment on, that were properly before the court, properly served, and the court properly heard the arguments before. Thank you, Judge.
All right, thank you, everybody. Court will go ahead and take judicial notice of the entire file, cause number CL 19-1616D, Berta Moreno versus Brisaida Gonzalez, 20 Randall Harris, Triple H Trucking LLC. Court will go ahead, take this matter under advisement. Please submit your proposed orders as soon as possible. Okay, gentlemen, you may be excused. Thank you. Stay safe.
Thank you.
Likewise.
Stay safe. Everyone stay safe.
Everybody stay
God
safe.
bless everyone. Thank you.
Thank you, sir. Judith and Sophia. Okay. Okay, we got Ready? That would be, Sophia's connected. Okay. I'm waiting for Miss Arispe to connect. Can you hear me, Miss Arispe? Can you unmute Miss Arispe? There you go. All right. Can you hear me?
Yes, I can hear you, Judge. Good morning.
All right. Good morning. Court will continue here with the July 15, 2020 docket. Next case here, F0377-20-4 in the matter of the marriage of San Juana Robledo and Lorenzo Robledo. Good morning.
Good morning, Judge. Judge Sofia Risper for San Juana Robledo, Judge. She is sitting here in my office with me.
Okay.
Good morning, Your Honor. Judith Cantu on behalf of Mr. Robledo, and he's also present here.
All right. Good morning.
Good
Yes,
morning,
ma'am.
Judge.
What do we have here?
Judge, this is a temporary restraining order hearing, Judge. Ms. Cantu called me about 2 minutes ago to tell me that there are some more warranty deeds, Judge, that have been prepared and transferred to Mr. Robledo, Judge.
Okay.
I've not seen those warranty deeds, Judge, so she and I spoken about having the restraining order extended to the final divorce decree, divorce hearing, Judge, because of the COVID virus. So we can try and review those documents, Judge.
Okay.
And I can talk to my client about options for settling the divorce, Judge. Previously, the court had also ordered Javier Ornelas to mediate this case. So I've told Ms. Cantu that if we can't settle, then we need to go ahead and do the mediation to try to resolve it, Judge. I also sent Ms. Cantu some discovery, but apparently she had not received it. So I went ahead and reissued the discovery to her recently, Judge.
Okay.
Judge, and that is correct. We anticipate that this case will be settled. I do have some documents that I need to forward to Ms. Arizpe. So we're in agreement in extending the TRO, and if we can get another hearing, I guess, for a couple of weeks. Or it has to be 2 weeks, right, Soph? I mean,
No, because of the COVID virus, Supreme Court's come down, allowing the courts to extend it further than the 14 days. And by agreement, we can extend it further than 14 days.
Correct.
That's fine, Judge. So I would ask that it be extended about 60 days, 60, to see if we can try to settle it.
Submit an order, please.
Okay, we will.
Submit
Yes,
an order,
Judge.
and we'll give you a date, okay?
Okay, we'll do the TRO again, Judge, and then the court can just put a date on there.
Yes, ma'am, and good luck with the settlement.
Thank you, Judge.
Thank you,
All
Judge.
right.
Have a good
May
day.
we
Y'all
be
may,
excused?
y'all may be excused. Thank you all.
Thank you.
Next, Robert Mesa. Is he by himself? And Robert Mesa? I thought Robert Salinas does it together. Okay. Good morning, gentlemen. Can you hear me?
Yes, Your Honor. Good morning.
Good morning. Mr. Salinas, you need to unmute.
Okay, can you hear me, Judge?
Yes, I can hear very clearly. Good morning, gentlemen.
Good morning, Your Honor.
I believe we're here on F1275-20-4 in the matter of the marriage of Rios and Rios.
That is correct, Your Honor.
All right. And what do we have here, gentlemen?
Your Honor, announcement for the record, Roberto Mesa Jr. on behalf of the petitioner Celeste Rios, Your Honor.
Yes, sir.
Robert Salinas for the respondents, Your Honor.
Yes, sir. And what's the announcement?
Your Honor, on this case, I did get an opportunity to speak to Mr. Salinas this morning. Ms. Celeste Rios is, I think she just connected on.
Yes.
We're set for a temporary order, Judge. I think majority of whatever they have, a lot of it is owed, and there's a lot of debt involved in the marriage, but there are 5 children. The request that we had for the temporary order was to allow an order for appointing temporarily the parties' joint managing conservators, having my client as the primary custodial parent of the children. Dad, as I believe, has access to the kids at this point in time. There's no issue with that as far as I'm aware. I believe he has made 2 payments, I believe, Your Honor, of $500 of child support for the month of, I believe it was June and July. He's currently not employed. He's on unemployment. There is a lot of debt, Your Honor, that I do know. He is making large amounts of payments on property that is owed, a mobile home, and I believe on a lot. So that I think is taking up a lot of the resources. But as far as the amount of child support, Your Honor, I mean, what we would like is to get an order, to have an order to allow the payments obviously to happen at a date certain. And then to allow the parties obviously to be appointed joint managing conservators with standard language, including language regarding disparaging remarks, things of that nature, and not to have any of the case to be discussed by either party with the children. The oldest child is 13. We have a 12-year-old, an 8-year-old, a 6-year-old, and then a 1-year-old just turned 1 year old here recently, Your Honor. So the children are pretty small, but that would be our request at this point in time, Your Honor.
All right, Mr. Salinas.
Please, the court, Your Honor, we have no problem with joint managing conservators and her being appointed primary. I really don't feel, Your Honor, and with all due respect to Mr. Mesa and the court, that we are in need of any temporary orders. They visit daily. They go together with the children to see this 5-acre place that they have where they have a wide mobile. They're together every day. There's been no disparaging remarks. There's been no complaints to police department. There's been no police reports. They're really quite amicable for a couple seeking a divorce. This case was filed by Mr. Mesa back in March. I think we're ready to have final hearings, Your Honor. I will concede and agree with Mr. Mesa. I don't think either party is in a position to pay for a mediator. They're heartstrung, 5 kids. He's unemployed, drawing unemployment. He's making $500 a month and paying $1,200 a month on a mobile home and $455 on the property. He's having to borrow from his parents. He is trying, and I think she's trying too. You know, I think, Your Honor, what I would like to recommend is that we have informal mediation. I think this case can be worked out. My client is a reasonable man, and she's a reasonable lady. Mr. Mesa is quite congenial to work with, and I think that informal mediation could arrive at a solution to the finality of this without them incurring any costs which neither one of them can afford. I've got no problem with temporary orders as far as the joint managing conservator. She'd be primary. The $500 a month, he's struggling, but he realizes that he's got to pay at least that. But like I say, I really don't see a need for temporary orders, but if the court wants to grant them as regards joint managing conservator and the child support, I don't think there's any need for any protective orders or the rest of the template orders that lawyers like us temporarily file. They don't have any safe deposit boxes. They don't have any joint savings account. They've got a lot of debts, but I think it can be worked out with informal mediation. That's what I would like to recommend to the court.
Okay. All right. Yeah, let's try some informal mediation. And maybe you can even settle it and give me a final decree for signature signed by everybody.
I think that happen, Your Honor.
Just submit it. Mr. Mesa?
Judge, I mean, as far as that is, we don't have an issue with trying to do this informally. We did discuss that a little bit earlier this morning, and I said that would be fine. The only thing would be is obviously is the temporary order. I don't think it's going to hurt anyone. I think it's set there in case something were to happen that we're not able to finalize this divorce, and then we have to come back and file hearings on he's not making a payment, he's not, you know, as far as the child support is concerned, and or that the kids are being kept over and, you know, things of that nature. So to avoid any and all that, I think a temporary order would be proper at this point in time, Your Honor. You know, and that way we can proceed with the next step.
I've got no problem. I've got no problem, Your Honor, with the temporary orders as far as custody, joint managing conservator, the child support, and I don't think there's a problem with disparaging remarks. If Mr. Mesa wants to include it on there, I don't have a problem with that. I don't think we need going into Facebook and distorting their social media. That hasn't been a problem. Like I say, they're together every day. They go to that little place they own and take the kids out there.
Okay.
So I think I have no problem with temporary orders as regards the essentials, Your
Okay.
Honor, the child support, the custody, and the disparaging remarks. If he wants to throw that in there, I don't think the rest is necessary. It's
Okay. Well, then go ahead and submit the temporary orders. I'll go ahead and sign them. And in the meantime, just work it out and hopefully it'll come into a final without having to have a hearing and everybody just signs on it. So
I
yeah,
think
give me
it
the,
will, Your Honor.
okay, just give me temporary orders.
I think it will be.
All right. Thank you all very much. Y'all may be excused.
Thank you, Your Honor. Have a great day. Take care.
You too. Thank you. Mr. Edward Sanchez? Mr. Edward Sanchez? Is he on?
Good morning, Your Honor.
Yes,
Yeah,
sir,
good
Mr. Sanchez. Good morning. You're here on F1477-20-4 in the interest of Danila Gonzalez et al.
Correct, Your Honor. Melissa Villarreal is my client. Our understanding is the respondent, who's pro se, out of town. I think he called into the court that he could not participate, wanted an extension of time, which we don't oppose. They're apparently working some things out.
Okay.
So it's a pass today, Your Honor, by agreement.
Okay, I'll put no action today and just submit an order, Mr. Sanchez, and we'll give you another quick one.
Get a reset.
Yes, sir.
They have already been reset in October, Your Honor, but I need to verify that.
I think, is he on? I think he's on.
Who's on?
Who's he?
No, the respondent is,
Yeah.
you said,
He's right there,
who's the respondent again, Mr.
Oh,
right here.
I'm sorry, Your Honor. Let me pull that up.
Can you hear me?
Yes, I can hear you. I heard it's another name as far as the respondent. Who's the respondent, Mr. Sanchez?
Claudio Gonzalez?
All right. I don't think that's the name I heard earlier. Because I wrote another name here. So it's Braulio Gonzalez?
Claudio.
Claudio.
Yes, sir.
Oh, Claudio. Okay, Claudio Gonzalez. All right, and he's here. All right, I see him now. And so what we're going to do here is take no action, and we're going to reset it for another date. Okay? Everybody will get notices of a new date.
If he can
Oh.
give Edward.
Okay.
Yes, and Mr. Gonzalez, you would need to give your email to the opposing attorney, okay, sir?
Okay.
He's in right
Can you do it right now?
Can I call him in?
Yeah,
Through phone?
yeah, go ahead and call him. Go ahead and call him.
Let me give you my number, Mr. Gonzalez. 287
Okay.
555.
Area code 956.
Yes, sir.
And what were the last four? I'm sorry.
Yeah, it's
55.
yes, 287 7555.
There you go, 75.
Oh, 75
55.
55. 287 7555.
Give us a call and we can go over the proposed decree with you and see what you what your feeling is about it. Okay.
Okay.
All right, very well, gentlemen. You all may be excused. Thank you so much.
Yeah. Have a good day. Thank you.
Yes, sir. Thank you. Next, we have Mr. Juan Ramos and Mr. Espinosa, Pilar Espinosa.
Good morning, Judge. Good morning, Judge.
Good morning. F1487-20-4 in the matter of the marriage of Marie Casison and Gerardo Casison.
Yes, Judge, the announcement was we were set for a temporary order hearing today, but we actually mediated the case, reached an agreement, and we'd like to put it on the record with the court's approval.
All right, so the case got mediated successfully. All right, and do we have the parties on? I see Marie Casison. I don't know if she can hear me or not. She needs to unmute. All right, good morning. Can you hear me, ma'am?
Good morning. I can hear you, sir.
All right, good morning. Anybody else going to be showing up?
Judge, I did provide Mr. Caisson the user ID and password just a little while ago, but I'm here present and we did mediate the case, so we're ready to proceed, Judge.
All right, let's do that. We're going to put some testimony, Mr. Espinosa.
Yes, Judge.
It'll be your client.
Yes.
All right, good morning, ma'am. Please raise your right hand. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You may put your hand down. Mr. Espinosa, you may proceed, sir.
Thank you, Judge. We filed a mediated agreement this morning with the court, so we're asking the court to take judicial notice of all documents on file.
Court will take judicial notice of the entire file.
Thank you, Judge. And also, we waive any notice for a final hearing because we are asking today's hearing to be a final hearing.
So noted.
Ms. Casison, can you state your name for the record?
Marie Ann Casison.
Okay. And prior to or at the time of filing the petition, were you a resident of Hidalgo County for the previous 90 days?
Yes.
And were you also a resident of the state of Texas for at least 180 days at the time of filing of the petition?
Yes.
Were you married to Gerardo Casison on or about September 1st, 1995?
Yes.
And are you asking the court for divorce?
Yes, sir.
And you're also asking for a name change, is that correct?
Yes, sir.
And your last name will now be Dacoco, D-A-C-O-C-O, is that correct?
Yes, sir.
So just for the record, what will be your full name now?
Marie Ann Dacoco.
And are you expecting any children at this time?
No.
Are you planning to adopt any children at this time?
No, sir.
Are there any minor children at this time in your marriage?
None, sir.
Now, we reached a mediated settlement agreement yesterday and we had a division of property. So I'm going to read that on the record and you tell me if this is what you agree on. The agreement was each spouse was to keep their own retirement accounts. Each spouse was to keep their own bank accounts that is in their name. Marie is to keep the 2015 4Runner Toyota in her name. Mr. Gerardo is to keep the 2015 black Toyota Camry, and he also agrees to take over payments. Marie agrees to transfer the name of the black Toyota Camry into his name. The agreement also reached was the medical insurance that Marie has, if allowed through the government, she will remain on Mr. Gerardo's medical insurance as allowed by the government because he was a government retired employee. The agreement also is that the credit card debt each one has will pay for their own. The agreement also is the house that is at 3717 North First Lane West, McAllen, will be awarded to Mr. Gerardo Casison. And in return, Miss Casison Marie will receive a judgment of $32,500 in equity minus $8,000 that he will take over in a tax debt. So you will end up with $24,500 in equity from the home on First Lane West. So far, is that what you've agreed to so far, Ms. Casison?
Yes, sir.
Also, that Mr. Casison will pay you $500 a month to pay for the $24,500, which with the first payment on August 15th. He will also pay for any joint tax debt, which is the reason you're getting the $8,000. He's getting the $8,000 credit. And also there will be an injunction as to any disparaging remarks for the protection of each spouse, a mutual injunction. Ms. Casison, do you think this is a fair and equitable division of the marital property?
Yes, sir.
Is there anything that I've left out that you want to put on the record?
No, sir.
Have you been satisfied with my legal services thus far?
Yes, very satisfied. Thank you.
Judge, I passed a witness.
I have
All
no
right, thank-
questions, Judge.
All right, thank you, sir. Once again, court will take judicial notice of the entire file. Court will go ahead and approve the agreement of the parties. Court will dissolve the marriage of petitioner respondent, and court will await the final decree of divorce for signature. So that'll do it. Thank you all very much. You all may be excused. Stay safe.
Thank you, Judge. You too. Stay safe.
Thank you, Judge.
Thank you.
Thank you, ma'am.
Judge, if I may, I had another hearing set in this court at 9 o'clock, but unfortunately I was on another hearing.
Motion to withdraw.
It was a motion to withdraw?
Yes, Judge.
Yeah, that got granted.
Okay.
Yeah, just make sure,
Then next, sorry,
just make sure you submit the order, okay, sir?
will do, Judge. And that concludes my business before this honorable court. May I please be excused?
You may be excused. Thank you, sir.
Thank you. Take care.
Yes, sir. Take care. Who's
Chantel, if you can log on to the 10:30.
We're gonna log on now, everybody, 10:30?